Welcome to another edition of Anglican Unscripted, the Supreme Court edition. I'm Kevin Carlson.
And I'm Alan Haley. And today is September 24th, 2015.
Welcome to another episode of Anglican Unscripted, and I have my good friend Alan Haley across the country. He resides in Northern California. I reside by the beach here in Milford, Connecticut, and we're going to talk law because yesterday the Diocese of South Carolina had their hearing at the Supreme Court of South Carolina, with which they are kind of haggling things out with that old thing up at 815 called the Episcopal Church. And I was watching the video live feed, and then I watched the archive again of the proceedings, and I was a little disappointed, a little discouraged, and then I started to get some phone calls from people who reside in our laity or clergy in the diocese saying, what happened? Was this good or bad? And I thought, well, this is a great chance to talk to Alan Haley, who's been before the U.S. Supreme Court and has tried cases and knows when things have gone good and when things have gone bad. And we've talked before about what we call the Hail Mary. You know, every once in a while, you watch the Episcopal Church just throw something way out, and boom, the ball gets caught. What we want to talk here a little bit about is what happened at the hearing. We're going to talk about a judge who should probably recuse himself, and we'll talk about why. And then we'll talk about what this does as far as the legal case for the diocese. First, what was the hearing about?
All right, the hearing was an appeal from the decision by Circuit Judge Diane Goodstein last February, denying reconsideration of her order in January, which directed that all property, real and personal, was the property belonged to the diocese controlled by Bishop Lawrence, Mark Lawrence, and not to the Rump Group, which was contending that it had title to those things, headed by Bishop von Rosenberg.
And she basically said neutral principles apply.
Correct.
The Dennis Canon has nothing to do with this. Go about your way. And
she was a trial court judge following a Supreme Court precedent. In 2009, the Supreme Court of South Carolina had handed down the decision in the All Saints Waccamaw case. And in that case, it held two things. It held that the Dennis Canon did not apply in South Carolina, and it held also that the people in the parish of All Saints Waccamaw perfectly legally changed their governing documents in accordance with South Carolina law, and there was no provision in the diocese governing documents prohibiting them from so amending their documents. So therefore they were free to leave the diocese. And that was the decision that she was governed by, saying that it's going to be neutral principles all the way, and that the Dennis Canon you don't have to worry about because it has no legal effect in South Carolina. Now, for those viewers who don't know the Dennis Canon, that's an attempt by the Episcopal Church at the national level to impose a permanent trust on all parish property everywhere in the Episcopal Church without the necessity of having individual parishes sign individual trust documents. They simply published a canon in 1979, which is a national rule, called the Dennis Canon, and that said all property held by any Episcopal parish throughout the church is held in trust for the Episcopal Church and for the diocese in which the parish is located.
Now, ironically, the precedent she cited was penned by the current head of the Supreme Court of South Carolina. So when we heard that, hey, it's going to go to an appeal, and we knew who this judge was, we're like, well, it's just going to be procedural. He's going to say, of course, didn't you read my opinion? And to stamp it, it'll go on its way. However, it gets to court. The Episcopal Church has their attorney give a nice summation of what's going on. And I don't know whose voice it was off to the side, but it sounded like presiding Bishop Jeffrey Shorey was over here adding comment to his summation. What was
Yes.
going on there?
Well, all right. First of all, the Chief Justice to whom you refer is still the Chief Justice of the South Carolina Supreme Court is Jean Hofer Toll.
Mm-hmm.
And she's a Roman Catholic, and her original opinion in All Saints was crystal clear. It was unanimous for the court, a 5-0 vote. However, only one of the other justices on the panel yesterday participated in that 2009 decision. There were 3 other justices, some serving specially, and they did not. So there were 3 new justices sitting yesterday, and one of those justices was the newest person elected to the South Carolina Supreme Court, namely Associate Justice Kay Hearn,
Mm-hmm.
Hern. And she was the one sitting over on the right and acting like an Episcopal Church cheerleader throughout the whole proceedings. It was very dismaying to see a judge so biased and so evidently biased and so not interested in arguing the points or making the points that were difficult and going into the reasons why the Judge Goodstein had decided what she did. She wanted to basically show Judge Goodstein as biased as in effect she was, and to make her discredit her decision and to help the Episcopal Church attorney in the argument by any means fair or foul that she could. Most of her questions to him were not questions at all, but softballs, which he could pick up on and say, "That's right, Justice Hearn. I agree with you totally, Justice Hearn. Absolutely, Justice Hearn."
She was actually making the points that he forgot to make.
Yeah, exactly.
It was an amazing thing to watch. Now, you and I know that justice is blind. And
Yes.
certainly any plaintiff can say, "Judge, you can't participate in this hearing because you are actually a member of the Episcopal Forum. You go to a church, an Episcopal church that separated and is part of the Episcopal Church. Certainly you don't belong here." But that's not going to happen, is it?
Well, if it happened, or rather, if it was going to happen, it should have happened before the oral argument.
Okay.
There should have been a motion to recuse filed, and probably nobody thought she would dare be so blatant about it. Everybody thought maybe the fact that she's an active member of an Episcopal church in the remnant group would restrain her and hopefully keep her from being too activist. But it was just the opposite. And the other thing that you mentioned that is, I think, particularly egregious in this instance is that she's a signatory member of the Episcopal Forum. Now, if you remember, the Episcopal Forum is the group that's started charges against Bishop Lawrence and in the Episcopal Church. And if you remember the argument yesterday, it was Justice Hearn who kept trying to bring the case back to how Bishop Lawrence violated his vows. And she even got Justice Toll to pick up on that at one point, where Justice Toll was saying, "I don't like all these weasel words, vows, and everything like that." But the case of the vows was not in front of the South Carolina Supreme Court. That was just Justice Hearn dragging that element in order to discredit Bishop Lawrence and try to make his case appear less worthy. Because, you can't sue in civil court a church can't bring a suit against a bishop for violating his ordination vows. That's what the disciplinary proceedings are for in the Episcopal Church. And they've already been through those, and they deposed Bishop Lawrence. So that is over and done with. It is not a case for continually harping on, and that to me was the worst thing that happened all day with regard to Justice Hearn and showed how blatant she was.
Well, we saw that. Now, what is the recourse if you have a judge that is totally biased?
Okay. Under South Carolina law, every judge and justice takes an oath of office when they assume the office, in which they swear to uphold, of course, the Constitution of South Carolina, but also to be impartial and to be fair to all litigants coming before them. And the being impartial is what it is. And the other thing they're supposed to do is avoid the appearance of any impropriety.
Well, she was doing everything except wearing a Catherine Jefferts T-shirt.
Exactly.
Okay.
I mean, it was the soul of impropriety, sitting up there and banging the drum continually for the Episcopal Church. So I think she violated South Carolina's Judicial Canon number 2, on the impartiality of judges, requiring them to be, and that would subject her to judicial discipline if, in the worst case, she ended up being the author of a majority opinion, a 3-2 decision by the 5 members of the South Carolina Supreme Court. And if she were to carry the day in favor of the Episcopal Church, I think there would be a substantial uproar in South Carolina.
Well, you say uproar, but what's the recourse?
The recourse would be to bring disciplinary proceedings and to have her disqualified, and then to reset the case for oral argument.
Okay, so what now are the options of the Supreme Court? They heard the case. Basically, it was an appeal to Judge Goldstein, and can they rule beyond the merits of what they heard?
No, not really. Their options are simply to do one of two things. They criticized Judge Goodstein for keeping Episcopal Church from putting on evidence of its hierarchy. Mm-hmm. And that's what it did to ad nauseum in the cases in Fort Worth, Quincy, San Joaquin, and Pittsburgh. That's what makes the records in these cases so huge, because it's document after document about how
I think they have 10 legal boxes they just send around to all the court cases, yes.
Exactly. And one expert to whom they paid over $1 million who says the same thing in every court. And so the idea that Episcopal Church is hierarchical, it really shouldn't be of any matter whether Judge Goodstein kept that evidence out or let it in, because it's, in the end, it's totally irrelevant to the issue in the case, which is, namely, who owns the title to, what do the deeds say on the title to the various parish properties, what do the deeds say on the diocesan properties, and so therefore that should be the end of it for the civil courts. They don't care whether it's a hierarchical church or whether it's James Jones down the street. An individual and a church are treated the same under neutral principles of law. The same principles of law apply to them. There's no special rule for churches, and that's the end of it. But what the Episcopal Church wants to do is go back to the 19th century when Episcopal churches got deference from the courts. They were allowed to pretty much say anything they wanted. This person's going to be the bishop, this person's going to not be, and we're going to own the property here, and what we say goes. And that's what the Episcopal Church is trying to go back to, and that was, those days were gone once courts started saying we're going by neutral principles and everybody's going to be treated the same.
Yeah, because I've been told by you that the courts will never rule on doctrine. They'll never rule on the canons of the church.
They can't, under the First Amendment. They can't.
All right.
Yeah.
So
that's to do so would be to establish a religion in the United States by having a court pronounce this is the doctrine of the Episcopal Church or this is the doctrine of the Catholic Church, and it has to be now constitutional law. So it just could never happen. So that's why
we say it can never happen. But what case did she cite? Wolf versus
Jones v. Wolf.
Jones v. Wolf, where the court did determine a church was hierarchical.
Well, it didn't determine it so much as said that it identified the past line of cases, which we call the hierarchical church cases, the deference cases. And it said those which started with the case of Watson v. Jones in 1872. The states can still follow that method if they want, but states can also apply this new method of neutral principles, which is what was applied in Jones v. Wolf it was a 5-4 majority, I think. Or maybe 5-3 with one justice recusing. But anyway, it was a decision, as I say, for the first time at the Supreme Court level that applied neutral principles of law, and that made it all right for every other state to start following the same procedure. So Jones v. Wolf was not a hierarchical church case and did not say anything about hierarchical churches. There was an unfortunate dictum by Justice Blackmun.
That's right.
Who, in the case where he got out of his judicial robes and put on his lawyerly brief and advised people as to what they could do to get around this decision. If they were a church, he said you could just pass a constitutional provision creating a trust, and it would be bound, the courts would be bound by it, provided it is legally cognizable. In other words, provided it meets the requirements of a trust. Now, people have taken that unfortunate language. In Connecticut, for example, your own state, your Connecticut Supreme Court said, oh, that means, Justice Blackmun was saying, there's now a new federal law of church trusts, and that the canon can create a trust which the federal courts and the state courts have to enforce, regardless of their state law. And
You know, it's
that
because,
was
I gotta say,
that was one extreme. And the old South Carolina Waccamaw case was the opposite extreme, where they said the Dennis canon doesn't count for anything. It doesn't create a trust. Where's the signature by the settlor?
that's right. And that's the important point. The settler. I get to choose who I associate with. I get to choose um,
What you do with your
ownership,
property.
what I do with my property. And this case, well, we're down here to the last couple minutes. There's two more things I want to talk about.
Right.
What should a parishioner trying to protect their property and their seal and their name be concerned about with this case?
At this point, I don't see the court going that far as to say that the parishes have to worry about the Dennis canon, because the unquestionable thing is the quitclaim deeds from the diocese to the parishes uh, eliminated that interest. And even Justice Toll, toward the end of the argument, was saying, that there's nothing wrong with the beneficiary of a trust uh, quitclaiming his interest back to the settlor.
Mm-hmm.
That eliminates the trust by virtue of merger. And so there's no longer any trust. And she was saying that no other justice challenged her on that. No one tried to say that's wrong or anything like that. So I see that that will be one of the principles, I think, that will come out of any decision that they make, regardless of whether they rule. The most they can do, if they want to rule in favor of the Episcopal Church, is send the case back to Judge Goodstein for a retrial and to allow all this evidence in and make another decision. They won't make a decision in favor of the Episcopal Church at this level. They can affirm Judge Goodstein despite all the evidence that was ruled out, because they could say, well, it was harmless. In the end, it didn't make any difference to the outcome.
Mm-hmm.
And so they could simply say, we affirm Justice Goodstein's result. The property and everything belongs to Bishop Lawrence. And hopefully that will be the outcome. But, until we see the opinion, we won't know how much influence Justice Hearn had on her fellow justices.
We've watched Supreme Court, U.S. Supreme Court hearings and stuff like that. Usually in the next couple of days, they sit down and lunch and hash out what they're going to do. How do state Supreme Courts usually do it?
Well, it was interesting. From watching the argument, I don't think these justices had any conferences or memos, whatever, circulating about the case beforehand.
I agree.
It seemed as though it seems as though they were each listening to each other.
The two guys on the left didn't even know what they're talking about.
Right, and it seemed they were listening to each other for the very first time.
Mm-hmm.
Oh, that's an interesting point, Justice so-and-so. I think maybe, what about this, And so it's going to be interesting, the first conference here, as to what they think. And there, I hope the bias of Justice Hearn is going to be so blatant and obvious. They're going to say, you've already made up your mind in this case. Why don't you just recuse yourself? That would be ideal if she would recuse herself at that point. That would leave a 2-2 possibility, of course, which would result in an affirmance of Judge Goodstein's decision if that were to happen. Mm-hmm. So, for that reason, her own church may strongly not want her to step down. But, as I say, she's already, in my opinion, transgressed the code of judicial conduct there in South Carolina. In any event, yeah. Well, as I say, in any event, I don't think a parish person has to worry at this point about the status of their property, bottom line. It would have to go a lot further. It'd have to go back down to a different judge and have a different outcome before they could get to that point.
Now, you only invoiced me by the half hour, so I got another 10 minutes here. Let's talk about Bishop Bruno.
Yes.
Yes. He was accused by a church of nefarious activities, browbeating some witnesses, things that are not accustomed to what you expect of I should say Episcopal bishop. You do expect this, a real bishop, a biblical bishop. And so it went to the Title IV committee, and they said, listen, we want you to make nice, at least say something nice to the parish, send them a sorry card, whatever it takes. Let's do a conciliar action.
Right.
What is your definition of conciliar action?
Well, it means moving toward a consensus with each party. In other words, there has to be some movement forward toward the middle ground that separates people if there's going to be a conciliation. Conciliation does not mean capitulation, and it does not mean that the other side gets totally dissed and said, well, your case is worthless. So it respects the worth of both sides. Yes, this is the Bishop of the Diocese of Los Angeles. He's got certain inherent authority, and let's let him do what he thinks he's going to do best here. But on the other hand, he's got to take care of this congregation, which has grown, beyond its expectations and is strong and vibrant, needs a church building. And so out of that should be fashioned some sort of solution that works for both parties. But he wasn't interested in that.
So, according to Title IV, what happens now?
It goes back to the hearing panel, or the reference panel, who decides next thing will happen is, well, there'll probably be a hearing, and which is a little more formal than a conciliation. They will hear from both sides on evidence, and the panel will make some recommendation. If it feels that there's been a canonical violation, they could push it on to the conference panel for a full trial on the issue of whether there's been a violation of the canons or not. But it's I may have that said just that backward. I meant the conference panel is the one that considers what they should do, and the hearing panel is the one that conducts the hearing on the violation of the charges. In any event, it's going to go to the next step in the disciplinary process, which is consideration of the charges on an informal basis before they're formally considered, if it comes to that. So each step, the outcome will be an offer to to Bishop Bruno to mend his ways and to make some apologies and steps toward the offended congregation. And at each point, if he draws his line firmly and says, no, I'm not going there, then it can be ramped up. Eventually, he could get either a disciplinary judgment, or he could get a pastoral directive from the presiding bishop telling him, you will do this. So that might be interesting too, because if it's going to happen, Justice Shorey is out of office come November 1st, so it would probably be presiding Bishop Michael Curry who may have to make that kind of choice.
Well, I do want to thank you for your time. We're up against my legal allotted time by the invoice, but I want to thank you so much. It's our 200th episode, and you've been a great help over the last couple years with bringing people legal advice. And I just want to
200 shows, Kevin. Congratulations, Kevin. 200
it's crazy,
shows.
Isn't it?
You and George just probably never envisioned how that would have turned out.
We thought after 5, the internet would have kicked us off,
I'm happy to have played a small part in your success. It's wonderful.
Thank you, and God bless.